Well, I'm going to introduce myself. I'm really the best attorney you're ever going to find. My name is Carl Habekost, and I'm a lawyer. And you know the difference between God and a lawyer? God doesn't think he's a lawyer. Okay. I'm going to talk about the National Labor Relations Board, employment handbooks, and what all has been going on. This is a really dynamic area of the law. What did I do? Is it moving? Hey, yes, that's what I'm talking about right there. I thought this was kind of an interesting way to go, and it goes with our theme of movies, Raiders of the Lost Ark. You know, we're going to be on a quest for the next 25 minutes or so to find policies that are acceptable by the National Labor Relations Board. Sort of like Harrison Ford in Raiders of the Lost Ark trying to chase down the Ark of the Covenant. We're going to try to chase down the arc of acceptable employment policies. It's a difficult task. You will note that the National Labor Relations Board has the word labor in it. One would think that usually means unions, right? Union management issues. Well, from 1935, when this agency began, until the mid-1990s, that was the case. They dealt pretty much with solely union matters. In the 1990s, we began the expansion of employee rights. FMLA, Americans with Disabilities, EEOC became more active, and the National Labor Relations Board didn't want to be left out, so they became more active in non-union work sites. Well, let's just imagine here that you have a handbook policy. Handbooks, okay? And you've got some policies in there. And let's see if they would be acceptable to the National Labor Relations Board. Let's have one rule that says you cannot do personal business on the employer's premises. Not that unusual. I've seen policies like that. Let's say you have another policy that bans any sort of solicitation or distribution of material if the employees don't want it. If I don't want what you're giving me, stop giving it to me. That's a reasonable policy. Let's say you have a rule that you're going to post online some comments. We want you to put a disclaimer that this is my opinion. This isn't the opinion of my employer. We also are going to prohibit any solicitation without our prior consent. Those are reasonable policies, we think, living here in Ohio. Seems reasonable. Well, what do you think? No. First one, violation of the law. It's too broad. Prohibit personal activity or business on the employer's premises. An administrative law judge for the National Labor Relations Board said it could reasonably be read to restrict employee communications about the terms and conditions of employment. It was overly broad. The individual, the employees, if you read this in a certain way, would be restricted from conducting union activity, discussing terms and conditions of employment during lunch break, before and after work. So that's invalid. Let's try the other policy. No! Violation. Invalid. The administrative law judge referenced an older case, a Ryder truck case, and said that the law allows employees to engage in union solicitation even when it annoys or disturbs employees who are being solicited. So this seemingly innocuous rule was invalid, according to the National Labor Relations Board. Well, let's try the other one. There we go. Oh, that's invalid too. Just because you put a disclaimer, according to this judge anyway, doesn't mean that that's valid. Now this one is very interesting. So I actually wrote down and actually quoted part of this. The judge said the rule is too broad because employees could interpret it to mean they could not even use their own computers and private email accounts to complain to each other about work conditions. This gets better. Further, the judge found the rule also could be interpreted by employees to ban the personal use of photographs taken at work. What? All they're asking you to do is just say, this is my opinion. That's all. So I had to quote the judge. Quote, "One can imagine an employee who observes unsafe conditions in the workplace and would believe he or she could not take a photograph with his or her iPhone and email it to fellow employees to generate support to resolve unsafe work conditions," close quote. Well, I don't really know what he was smoking. I don't know how you get there from this disclaimer, but that's what we're dealing with. Well, let's see if we've got another policy that's acceptable. Why do I keep pointing it that way? Well, unfortunately, this one was also found to be unlawful. You cannot prohibit solicitation because you can't require prior approval. The judge said that this constituted an unlawful restriction on the right of employees to solicit on behalf of unions. So these are 4 policies we just imagined that happen to also be realistic. The judge found, nope, you can't have these policies. That's what we're dealing with. Now, who is this creature from the swamp here, National Labor Relations Board? Let's just talk about it real quick. It's on the screen. Independent federal agency that protects the rights of private sector employees to join together with or without a union to improve their wages and working conditions. One could wonder, with that mission statement, how they get into employment handbooks. We'll talk about that in a minute. There's a board that we said, National Labor Relations Board, that administers and enforces the National Labor Relations Act. The board is 5 members. They have 5-year terms. Each term ends every year, so you have a term ending every year. The members of the board are appointed by the president and confirmed by the Senate. So if you don't think politics matters, don't vote. You're going to get what, maybe you don't like what you're going to get. So politics does matter. There is also a general counsel. I don't have that listed. General counsel is also appointed by the President of the United States and confirmed by the Senate. He's the head honcho bottle washer attorney for the organization. Then you have several administrative law judges. They're the first level. They hear the cases that come before the National Labor Relations Board. There's about 34 of those judges at any one time. They have their offices in New York, Washington, D.C., and San Francisco. They go all over the country and they hear cases that go to trial. They also try to effectuate settlements. Finally, the board has regional offices all over the country. I'd let you know we're in Region 8. Region 8 covers about 55 different counties in the state of Ohio. Now, what does the board do other than cause us hassles? Well, it monitors union elections, it investigates unfair labor practice charges, it decides cases, as I talked about, also enforces orders, its own orders. Why does the National Labor Relations Board even care about handbooks? That's how I started. This is not in your handbook, your printout, so look up here on the screen if you want to follow along. And so I found a case that sort of answered that question. Lutheran Heritage Village. Being Lutheran myself, I don't know, whether I like this case or not. But the case addressed work rules. And the crux of this case is that the mere maintenance of a work rule may violate the law. if it has a chilling effect on the employee's right to discuss the wages, hours, terms, and conditions of employment. It's known as Section 7 rights to those of us in the business. And the case, Lutheran Heritage case, promulgated a three-prong test. And it's important that we talk about this just for a second. 3 prongs. First prong is most important. Would an employee, quote, reasonably construe, close quote, the rule's language to prohibit Section 7 activity? Well, what does that mean? I mean, it doesn't say an ordinary, reasonable, prudent person, which all of us in the law deal with. This just says an employee could reasonably construe something. And you're going to find things like an administrative law judge saying you have to put a disclaimer when you put something out on the internet that it's your own opinion, and then that judge launches off and says he interprets it as violating the law and dampening Section 7 rights. The second prong of the test was this rule created purely in response to union or other Section 7 activity, and the third prong was the rule actually applied to restrict the exercise of Section 7 rights. So that's the 3-prong test. Now, the Labor Relations Board has gotten so active, sticking their nose into the employment relationship, dealing with work rules and handbooks, that practitioners on both sides of the table, management and labor, went to the general counsel and said, please, for God's sakes, can you give us some kind of guidance here? We don't know what you're doing. What do you want? What's the requirement? And the Office of the General Counsel put together a memorandum. Memorandum was issued about 1.5 years ago, and it provides some examples in various areas: confidentiality rules, professionalism rules, anti-harassment rules, photography, media contact. It sort of covers the gamut. Oh, today I'm going to give you a few examples. We can't possibly cover all these different areas. But what you'll find when I give you the examples, and we're going to go through a few cases now, is that the primary point in this area of the law is remembering that employees have the right to discuss the wages, hours, terms, and conditions of employment. And that's where all of these cases fall or rise, is on that analysis. I'll give you an example. Do not discuss, this is a confidentiality rule out of a handbook. Do not discuss customer or employee information outside of work. That includes the personal phone numbers and addresses of employees. That was found to be invalid and violated the law. Anybody have an idea why? Yeah. That's exactly right. The answer to the question was because union organizers will use that information, employees' names and contact information, to organize. So the National Labor Relations Board said, no, it's too broad, it violates the law. Now, this was one that was sort of basically a definition rule, and it defined what confidential information is. All information in which its loss, undue use, or unauthorized disclosure could adversely affect the interests of the employer, the image and reputation of the employer, or compromise personal and private information of employees. That similarly was found to violate the right of employees to discuss wages and working conditions. The employees need to have the right to share information in support of complaints. The rule would reasonably lead employees to believe that they cannot disclose that kind of information because it might adversely affect the employer's interest, image, or reputation. So that's where we're at. Now, let's look at what I would call a real case. This is a Boeing case from about a year ago, a little bit over a year ago. An employee filed an internal complaint. She claimed she was harassed by her supervisor. And the investigation began. They had a long-standing policy: do not discuss any ongoing investigation with other employees except management, because management supervisors are the ones who did the investigation. Well, the employee by the name of Joanna started talking to her coworkers about the complaint. Then she was fired for violating the confidentiality policy. I like this slide. It fits Halloween, doesn't it? Now, why do you have confidentiality policies? What did Joanna do wrong? So you have policies to protect the witnesses, protect the complainant, prevent destruction of evidence, prevent a cover-up, prevent collusion, people getting together, talking about this so they get their story straight. That's why confidentiality rules are important. The board said, however, that she was fired unlawfully. The policy was overly broad. It restricted her ability to discuss the what. That's the wages, hours, and terms and conditions of employment with her other employees. So they sort of discussed what would be a new rule on confidentiality. Confidentiality cannot be enforced unless there is a need for it that outweighs the employee's rights under Section 7. Section 7 is discussing wages, hours, and terms and conditions of employment in that specific case. So you cannot have just a plain broad confidentiality rule that does not, at least somewhere in there, discuss the specifics of the case. Hence, each case is now fact-specific. The employer has the burden. Only if the employer determines that a corruption of its investigation is likely to occur without confidentiality may the employer prohibit its employees from discussing these matters among themselves. So, question: how do you determine whether it's going to be corrupted? How do you know? Tybo, you can't answer. So you see how difficult this is? This is why a lot of labor attorneys drink, because they can't figure this out. I mean, it's a moving target that you're trying to hit. Interesting quote from Vince Lombardi that is totally random, but I wrote it down and I forgot to say. If you're not fired with enthusiasm at your job, you will be fired with enthusiasm from your job. So at this point in the presentation, you're probably getting a little unenthusiastic, and I thought I would give you a Vince Lombardi quote to pump you up. What about social media? Can you do anything on social media as far as protecting your company? Well, the general counsel weighed in on that in his memorandum. I'll give you an example, a couple of examples. Do not make insulting, embarrassing, hurtful, or abusive comments about other company employees online, and avoid the use of offensive, derogatory, or prejudicial comments. Now, I looked at this from two different angles. Number one, you want to have an image of your company that is appropriate, but the other thing is we have bullying in the workforce now. And bullying leads to workplace violence. So you can nip it in the bud with some policies like this, I used to think. But the National Labor Relations Board said that because debate about unionization and other protected concerted activity is often contentious and controversial, employees would reasonably read such a rule that bans offensive, derogatory, insulting, or embarrassing comments as limiting their ability to discuss wage and hour issues. So these terms would also reasonably be construed to limit criticism of supervisors and managers because they're also employees of the company. and controversial. Employees would reasonably read such a rule that bans offensive, derogatory, insulting, or embarrassing comments as limiting their ability to discuss wage and hour issues. So these terms would also reasonably be construed to limit criticism of supervisors and managers because they're also employees of the company. So that policy, social media policy, is invalid and unlawful. Similarly, do not send unwanted, offensive, or inappropriate emails. They don't like the word inappropriate. Doesn't have any definition to it. So you have to use examples. And you cannot use a blanket ban of sending unwanted or offensive emails for the same reason we just talked about. Well, let's see if we've got a case that actually discusses this. Well, we all know what social media is, right? Facebook, LinkedIn. Good. Can an employee be disciplined and discharged for what they say on social media? Years ago, I had some cases where an employee was actually, a couple of them were fired for what they said on Facebook about the company and dealt with it in the context of unemployment claims. It was a different world back then, and that was only 6 or 7 years ago. Now, I think you have to answer, according to the National Labor Relations Board, no, because the conduct and speech is probably protected by the Act, probably. Here's a case. Some of you probably have heard about this, but it's an interesting case, so I'm going to talk about it again. Triple Play versus Sanzone. Now, some employees of this company were upset. Whoever was handling the payroll didn't take out the appropriate amount of taxes from the paycheck. So they withheld an improper amount at the end of the year. The employees owed state taxes. So someone posted on Facebook, maybe someone should do the owners of Triple Play a favor and buy it from them. They can't even do the tax paperwork correctly. Now I owe money. WTF. Other people started chiming in. It's all Ralph's fault. It's a funny story, again random. I have a brother named Ralph. He named his son Ralph. My sister married Ralph, and they named their first son Ralph. So when I go to a family reunion and somebody says Ralph, I get 4 people coming. It's crazy. And it's always Ralph's fault anyway, my brother. So he didn't do the paperwork right. I'm calling the labor board to look into it because he still owes me about $2,000 in paychecks. Now think about this. 10 years ago, would you have thought to call the labor board over an issue like this? You see see the change? Like the employees are thinking the labor board now can handle all of my problems. And they're doing a pretty good job for the employees. Sanzone wrote a negative post with profanity, laced with profanity. Spinella liked it. Does everybody know what liked means? Like you're on Facebook and you read something and you can like it. Well, what happened was that the employer caught wind of this, and the employer said, you know, that's inappropriate. Both Sanzone and Spinella violated confidentiality policy. What did they violate? They were talking about tax information, payroll information. The employer considered that confidential. They also violated a professionalism policy, similar to the policies I just read to you. You should not use inappropriate language, any abusive language. So they were terminated for violating those 2 policies. The National Labor Relations Board said Sanzone's post was protected because it was a discussion with other workers about the calculations of tax withholdings that constitutes terms and conditions of employment. So you violated Section 7 rights. Spinella could not be held responsible because all Spinella did was go like and said that she liked the comments of others. And there's really not a lot of analysis on that. I guess liking's okay. So the result was both of these employees were put back to work with full back pay. Exciting stuff, isn't it? Here's a recent case, last case. I think I'm running on time, pretty close. June 2016. There are 3 handbook rules. Now, this case is, yes. In this particular case, the company is Schwann. And Schwann is, you've seen the trucks where they deliver food and all that, the Schwann trucks. Well, they're amazing. There are like 7,000 employees for this company. 7,000. They have 400 offices all over the country. Most of the employees are these drivers you see driving around and delivering food to homes. There are some forklift drivers and very small amount of office employees. No matter what, all of these employees have to abide by handbook policies. There was an unfair labor practice charge, and the NLRB got into looking at the handbooks, and they saw 3 rules that they didn't like. 1, restricting disclosure of company information. 2, requiring pre-approval before disseminating information containing the company name. And 3, prohibiting conduct, you can see a theme, detrimental to the company or its employees. In a little more detail. Rule 12, security of company information. Now, this rule was interesting because the language that the National Labor Board did not like was contained in a paragraph about trade secrets. So the full text of the rule is that you're not permitted to reveal information, but it discussed that information includes trade secrets, including but not limited to information on devices, inventions, processes, compilations of informations, records, specifications, and this was the one that killed them, and information concerning customers, vendors, or employees. So that information was not to be disclosed. The board said that we find that an employee would reasonably understand this rule to restrict disclosure of information to union representatives. And so the board cited some prior cases and said this rule is invalid. The second rule, Rule 17, the board did not like this rule particularly because they said that it was overly broad. It prevented any sort of discussion about the company. Employees have a clear right under the Act to publicize labor disputes. So the company can criticize the company, the employees can criticize the company, use the company name, and that, that's fine. But we all understand that wasn't the intent of this rule. The intent of this rule was if you're going to go talking about Schwann's and you're going to, discuss Schwann's on the internet, discuss wherever, we want to make sure you're doing it appropriately. But the Labor Relations Board said it violated the opportunity for unions to criticize the employer. Finally, conflict of interest. This is sort of a broad rule, and it was found to be ambiguous, and it could be reasonably construed to prohibit Section 7 rights. So I ask you, as I did early, what is not protected activity? The board is going to find pretty much anything I want to say as activity that would lead me to discuss terms and conditions of employment. Well, we're at the end. I usually have some jokes, but I ran out of jokes. A couple of sayings that'll give you some inspiration. Courage is the ladder on which all success climbs. So no matter how crazy this area is, I think it's going to calm down. Successful people are not people without problems. They're people who solve problems. This is a moving target. We don't really know where it's going to end. We want you to have this information. If you're going to have policies, just be specific, give some examples. Call Bugbee and Conkle. We can always help you. Always do right. This will gratify some people and astonish the rest, according to Mark Twain. So look at that. Perfect. The big 0 came up back there, and I'm out of time. So thank you very much.